This is an NBC News special report. Here's Chuck Todd.
We have breaking news from the Supreme Court, and this has the potential to impact at least the political standing of the president and possibly the presidential race. The justices have just ruled against the president's attempts to shield his financial records and tax documents from New York prosecutors. NBC Justice correspondent Pete Williams is with us to explain. And Pete, there were a couple of cases here having to do with the president's financial records. One was in New York City and one was with Congress. What do we know?
So the president must turn over his taxes to the grand jury in New York unless he can come up with the same kind of arguments that any other person would be able to raise as an objection in court. So the Supreme Court sent the Vance case, the New York grand jury case, back to the lower courts, but it took away all the arguments the president made about why he is different and special, that he's absolutely immune from the criminal justice process, and that allowing local district attorneys to seek things from the president would subject the president to harassment. So what the Supreme Court says is, okay, now go back to court and make the same kind of arguments anybody else would make about why you think these subpoenas are intrusive. It puts him on the same standard, basically, in other words, as anybody else trying to block a subpoena, makes it much, much, much harder for the president to keep this material out of the hands of the grand jury in New York. On the congressional subpoena, the Supreme Court has also sent the case back. It is said the president absolutely can't say no, but it is said in a case like this where a congressional subpoena is so broad, there's a test that the lower courts have to apply. They have to make sure that this is tethered to some legitimate legislative purpose, that it's not going to harass the president. So it's set out a series of steps that the lower courts have to look at. So bottom line here, Chuck, number one, nothing's going to get resolved in these cases until after the election because they go back to the lower courts. Whoever loses there has a chance to appeal. It could go back to the Supreme Court. That's the first thing. Second thing, even if the New York grand jury had gotten a complete, absolute win here, that wouldn't mean that we would see the president's tax records because of the rules of grand jury secrecy. Even if the grand jury ultimately gets the president's taxes and he can't come up with any good objection for why he shouldn't turn them over, they don't become public. And the only way that we would ever see them is if there's someone indicted and goes to trial and the taxes are introduced as evidence. So those are the two bottom lines. Nothing's going to be resolved before the election. We're not going to see any of this stuff on the congressional subpoenas. You know, if the president ever did turn over any of his business records to Congress, they might ultimately become public, but it's going to be months and months and months, possibly a year, maybe two, before this is fully resolved in court. So it's a mixed day for the president. He doesn't have to do anything right now, but the idea that he can put a barricade around the White House and say, no, I don't have to respond to any of you, that's a dead letter now.
All right, a couple questions for you, Pete. First one is, essentially the Supreme Court, it sounds like, has put down metrics, if you will, or sort of a checklist on what access Congress could have. I assume this now sets new precedent for presidents going forward. Is that what this decision will end up being for when it comes to the personal financial ties of presidents going forward?
Well, absolutely. Both of these decisions are precedent setting because we've never had before. The Supreme Court has dealt before with the issues of whether presidents are immune from subpoenas. They answered that in the Nixon case. Are presidents immune from the legal process while they're in office? They answered that in the Clinton case. But we never had a case before of a state prosecutor seeking material from the president. And that raised all sorts of, supremacy clause questions and everything else. So number one, the Supreme Court has said, they shot down the president's two arguments, which was presidents are absolutely, because they can't be indicted while they're in office, they're immune from any part of the criminal justice process, including subpoenas. Okay, we now know that's not true. So yes, precedent is set there. And secondly, the court has laid out a number of tests that have to be applied when Congress and the president are at absolute loggerheads. Are these subpoenas narrowly focused? And, frankly, I think the Democrats were their own worst enemies. These are such broad requests for documents from the presidents, his relatives, over many, many years. So are they sharply focused, the requests from Congress? Are they tied to a legitimate legislative purpose? Remember, Chuck, there's nothing in the Constitution that says Congress has subpoena power. The courts over the years have said, yeah, Congress needs to find things out when it wants to legislate. What Trump's argument here was, this is a fishing expedition. You just want all this stuff to poke through it and see if you can find something, then go, aha. And, you know, the Supreme Court sort of met him halfway on that one to say this has to be tied to some legitimate legislative purpose.
And Pete, very quickly, what were the makeups of the rulings?
7-2 on both cases. Roberts and the liberals, the dissenters in both cases were Clarence Thomas and Samuel Alito.
Hey, NBC News viewers, thanks for checking out our YouTube channel. Subscribe by clicking on that button down here and click on any of the videos over here to watch the latest interviews, show highlights, and digital exclusives. Thanks for watching.